staff in 1974, teaching classes in both philosophy and religion. And it's in his honor that we host this dialogue every other year. The funding for this event has been generously provided by the William Howell Furr Foundation. So on that note, I would like to take a moment to acknowledge Professor Furr's family members who are in attendance with us today. So sitting here in the middle, Libby and Susanna Furr, Professor Furr's daughters, two of them, and also his brother, Ray Furr. So please. Professor Furr was an advocate of religious pluralism, and he was also a proponent of civil yet rigorous discussion of contemporary religious topics, both inside and outside of the classroom. And it's in that spirit that we decided on the topic for this year's dialogue, namely, what is the impact that two of the world's great religions have had upon the legal system here in the United States? We're very fortunate to have two very fine scholars with us today who are going to address this question. Before I introduce them, however, let me say a few words about our format. Each of the speakers is going to present for approximately 25 to 30 minutes. And then we will follow that up with a period of question and answers from the audience. The main presentation should end around 5:30, and we hope to conclude the question and answer section by around 5:50, so that those of you who have 6 o'clock classes may get to those on time. At this time, I'd also like you to make sure your cell phones are off, or at the very least muted, so that it doesn't interrupt the event as we move forward. Okay, it is my great pleasure then to introduce our two speakers to you. On your right then is Professor Kathleen M. Moore. She is Professor and Chair of the Religious Studies Department at the University of California, Santa Barbara. Professor Moore teaches courses on religious liberty, Islam in America, and Muslim diasporas and the law. Her research focuses on Islam and Muslims in the United States and Western Europe, and the regulation of religious self-determination in secular democratic societies. She currently directs a 2-year research project funded by the Luce Foundation, which is called Sharia Revoiced, documenting how California Muslims experience Islamic law. Her publications appear in the Oxford Handbook of American Islam, the Cambridge Companion to American Islam, and the Rutledge Handbook of Islam in the West. And she has several books published. The titles include The Unfamiliar Abode, Islamic Law in the United States and Britain, Muslim Women in America, Challenges Facing Islamic Identity Today, and finally, Al-Muqtaribun, American Law and the Transformation of Muslim Life in America. She's currently editing a book on women's religious liberty, religious authority in Islam. In her leisure time, she chairs the board of directors of the Interfaith Initiative of Santa Barbara County, and she also enjoys attending her son's basketball games. Please give her a warm welcome. To your left then is Professor Lisa Shaw-Roy. She is Professor of Law and Jesse D. Puckett Jr. Lecturer at the University of Mississippi School of Law. She teaches courses in Law and Religion, Constitutional Law 2, the First Amendment, Legal Ethics, and Religious Liberty Litigation. Her scholarly interests include questions of church and state and the interaction between religion and law. She's the author of law review articles published in various journals, including the Michigan State Law Review, the Northwestern Law Review Colloquy, the Penn State Law Review, the Oregon Law Review, and the Harvard Journal of Law and Public Policy. She's a member of the Law and Religion section of the Association of American Law Schools and a past co-chair of that section. Professor Roy is going to be our first speaker, so please join me in welcoming her as she makes her way to the podium.
Good afternoon. I'm delighted to have been invited to participate in this conversation on religion and law. So thanks very much to the organizers of the dialogue and for the invitation, to Professor Voss and to the hosts, the Philosophy and Religion Department, to the Furr Foundation and the Furr family. I was asked to speak about the impact of Christianity on the law, and to do that in the context of a few recent U.S. Supreme Court cases. And so when we think about Christianity's influence on various social movements that influence law, We might think about social movements, including the abolition of slavery, or perhaps the campaign against alcohol and prohibition. We might think about the civil rights movement with its religious imagery. We might think about Christianity in a more current frame in the context of today's culture wars and what that means for the cultural and legal landscape. But when we talk about Christianity and law in the United States, there's a connection to the law of religious liberty. We might ask, how has Christianity shaped and how has it been shaped by the law of religious liberty? By liberty, I mean a particular concept of liberty. I mean liberty is the right to believe and to act on that belief. Claims of this type of liberty show up in the Supreme Court's two most recent religion decisions, Hobby Lobby versus Burwell and Holt v. Hobbs. Last term, the U.S. Supreme Court held that a large craft store chain owned by Christians was entitled to an exemption from the contraceptive mandate. Hobby Lobby stores versus Burwell, of course, held that the Affordable Care Act contraceptive mandate violates the Religious Freedom Restoration Act inasmuch as it included forms of contraception that violated the owner's religious beliefs. And earlier this year, the Supreme Court decided Holt v. Hobbs, a religious liberty case decided under the Religious Land Use and Institutionalized Persons Act. In Holt v. Hobbs, the Supreme Court held that a Muslim prisoner in Arkansas was entitled to an exemption from the prison rule against wearing a half-inch beard. Holt v. Hobbs and Hobby Lobby differ in their facts, in their claims, and in the religions at issue. One involved Christian business owners and another a Muslim prisoner, but they share a common history and pedigree and are part of a larger story of religious history and liberty. So what is that story? Well, it begins in the Supreme Court, and the place that I always like to begin in my classes is with the First Amendment, but I see you've got that up on the wall, the text of it, and so that's inspiring to me, but we could look at that and see that it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And so religion, in terms of its exercise and not establishment, are mentioned right there in the First Amendment. In the Supreme Court, in the early U.S. Supreme Court cases, the first half of the 20th century, the court began to recognize religious liberty, most often in cases involving Jehovah's Witnesses who engaged in street preaching and door-to-door pamphleteering. But this was no ordinary handing out of pamphlets. It also included giving speeches, playing records, and in all of it, engaging in anti-government and anti-religious, and in particular anti-Catholic speech, that was extremely unpopular in the times and in the places that it occurred. The court repeatedly affirmed the rights of Jehovah's Witnesses under a rubric that treated speech and religion together as equal parts of First Amendment freedoms. Now, much earlier, in the late 1800s, the court had considered whether the practice of Mormon polygamy might be protected from regulation under the Free Exercise Clause to the federal Constitution. The answer was a resounding no. The court also laid out the problem with a claim of religious liberty under the Free Exercise Clause. Where do you draw the line? If you believe in human sacrifice, do you get to act on that belief? As the court put it, to recognize that kind of liberty would be to make the professed doctrines of religious belief superior to the law of the land, and in effect, to permit every citizen to become a law unto himself. Government could exist only in name under such circumstances, the court said. So when the court did decide to recognize free exercise as a separate freedom with its own jurisprudence and analysis, the first case was Sherbert v. Werner in 1963, which involved a Seventh-day Adventist who was denied unemployment compensation because she refused to work on Saturday in violation of her faith. This was confirmed in a later case in Wisconsin v. Yoder in 1973, involving the Amish, who refused for religious reasons to send their children to school past the 8th grade. To answer the question, where do you draw the line in allowing someone to act on their belief, the court set up a balancing test. These cases held that where the government had substantially burdened the claimant's religious practice, the government would have to justify that burden with a compelling reason for applying the law. The government set up a test that required it, and importantly, lower courts, to balance the infringement on religious liberty against the government's reasons for imposing the law without exceptions. Sherbert and Yoder established a test that made it harder for the government to win, but there were plenty of religious claimants who lost at the Supreme Court as well. So in 1990, when the court decided a free exercise case involving Native Americans who were fired for ingesting peyote and therefore denied unemployment compensation, it was a case that they could have won or lost. Now, there's an obligatory joke that goes with this case that all the law students know, and because it turns out that the individual claimants were fired from a drug rehabilitation facility. But no matter, they were ingesting peyote, a hallucinogenic drug, and that was the burden on their religious exercise, that they were denied unemployment compensation. And so, as I said, it was one that could have been won or lost. On the one hand, it was unemployment compensation, just like those earlier cases. But on the other hand, the government generally can come up with very good reasons for wanting to enforce the drug laws. But exactly 25 years ago, well, so tomorrow, April 17th, will be 25 years, the court handed down Employment Division versus Smith, and it shocked court watchers and religious groups, academics, and civil liberties groups, not necessarily because the claimants lost, but because the methodology in free exercise cases was different from the balancing test of the earlier cases. That is, the government would no longer be required to justify religiously burdensome laws with a compelling reason. Instead, as long as the law is neutral toward religion and can be applied to everyone, then it would be valid. Now, the earlier cases had involved either religious minorities of the Christian variety or sort of sects identified with Christianity, Seventh-day Adventists, Jehovah's Witnesses, or the Old Order Amish, but Smith involved a religious claimant who was neither Christian nor Western. Al Smith, the principal plaintiff in the case, wanted to ingest peyote, as I mentioned, as part of the ceremony of his Native American church. He was a religious minority in a true and least contested sense of that term. So the Supreme Court in Smith, in contrast with those earlier decisions that employed the balancing test, held instead that religious minorities must seek protection to the political process and not the courts. And so, kind of the next stage, the next phase in the story of religious liberty and religious freedom shifted from the courts then to Congress. Employment Division versus Smith, the case that I described, ignited a firestorm of criticism and provoked a widespread response from groups across the political and ideological spectrum. Conservative and liberal, secular and religious, these groups agreed on one thing, that Smith had downgraded the protection of religion under the Free Exercise Clause. So this unlikely coalition resulted in the passage of the Religious Freedom Restoration Act of 1993, commonly called RFRA. But this wasn't the last part of the legislative story. Congress had acted in a way, perhaps, that the Supreme Court had predicted in Smith, at least in terms of its language about the political process. It attempted to safeguard religious minorities, but it went further than the court likely anticipated by passing RFRA, a wholesale religious liberty law that, in its own words, aimed to restore the compelling interest test, the balancing test, from those earlier cases, Sherbert and Yoder. So in a later case, the Supreme Court rebuked Congress for passing RFRA under the enforcement power of the 14th Amendment to essentially overturn that earlier case, Employment Division versus Smith, and restore the rule from the previous cases. It would later become clear that RFRA could be applied to federal law, but not state law. One solution that advocates and lobbyists had considered, at least those lobbying for religious freedom protections, was to pass maybe another law just like RFRA with stronger jurisdictional footing. And so after the Supreme Court invalidated RFRA as to state law, there was a move to try to restore the balancing test through another piece of legislation that would have a different jurisdictional basis. But the coalition to restore the balancing test generally as to the federal government and the states broke apart over a couple of issues, at least a couple of issues, that is. On the right, it splintered over whether invoking the commerce power unduly expanded the reach of the federal government, and on the left, over whether the new law could be used, or whether it would be used as a defense against anti-discrimination laws. So another wholesale across-the-board religious liberty law like RFRA was never enacted. So RFRA remains the law at the federal level, but at the state level, there are state or mini RFRAs that were and have been enacted to provide protection. Advocates might also turn to state constitutions for protection. The coalition, though, to restore the balancing test did hold together long enough to pass a narrower law, that is, a law that focused on a couple of narrow categories. So it still applied the balancing test, but in the case of this new law, the Religious Land Use and Institutionalized Persons Act that passed in 2000, it applied to two categories, land use and prisons. Why land use? Well, land use was an issue in the case that overturned RFRA as to state law, the federal RFRA as to state law, And there was evidence showing that churches, synagogues, and mosques faced particular difficulties with zoning laws. Why prisons? Well, prisons are a setting in which the needs of religionists are, but just by definition, by the nature of the setting, dependent on the government. And so RLUIPA, as we call it, the Religious Land Use and Institutionalized Persons Act, then was passed with these two settings in mind. Now, there was a noteworthy parallel development going on at the Supreme Court as well. And so I think before we conclude that the federal statutes then became the vehicle for protection of religious liberty in the courts, there's really this other development that's part of the story. Beginning in the 1980s and then continuing for several years, religious liberty was also being protected by means of the free speech clause. First in the case of a university student group that wanted to hold religious services on campus at the University of Missouri at Kansas City, and then in a string of cases that involve similar settings. And so with respect to access to church facilities or access to school facilities by church after hours under use policy, with respect to notably a university student group that wanted to have their printing expenses paid for under a student activity fund, and then other groups that wanted access to school facilities. In all of these cases, the court really solidified this line of free speech cases that use the speech clause as a way of protecting religious speech under an equality rubric that constituted really a prohibition on what the court called viewpoint discrimination. And so this was essentially in practice a line of cases that tended to work in favor of Christians who'd been excluded from access to public facilities based on government concerns about violating the Establishment Clause, that other part of the First Amendment religion clauses. Practically speaking, this was a litigation campaign largely fought and won on behalf of evangelical Christians, those most likely to seek access to such facilities for things like study, discussion, and worship. But by this time, Christians were not just the claimants in the cases, they were also the advocates. And so a number of explicitly Christian litigation firms sprang up in response to the perceived need for legal protection, and many of these firms and advocates took cases that defended the religious liberty of non-Christians as well. And so a natural outgrowth of these cases and ones under the religious liberty statutes that I mentioned was the way in which religious liberty law became part of the legal culture. And so now how does all of this come back to those first two cases that I mentioned and thoughts about religious liberty in the law? Well, if we fast forward a few years, there's a notable development at Stanford Law School. In January of 2013, Stanford became the first school in the country to open a religious liberty clinic. Since its inception, that is the Religious Liberty Clinic at Stanford, students in the clinic have represented a variety of different religionists and various disputes over land use and accommodation and employment, public schools, and in prisons, to name a few. Their cases so far have included claimants from the Buddhist, Native American, Sikh, Jewish, Orthodox, Seventh-day Adventist, Muslim, and Hare Krishna faith traditions. And the Stanford Clinic was initially supported with a significant donation by the Beckett Fund for Religious Liberty, which brings us back to Hobby Lobby and Holt v. Hobbs. Both Hobby Lobby and Holt v. Hobbs were represented by, among others, that same group. So now, if we think sort of kind of up to current times and these recent decisions, the one earlier this year in Holt v. Hobbs and then last year in Hobby Lobby, how do we understand the claims of religious liberty in those cases? Well, both Hobby Lobby and Holt v. Hobbs were decided in favor of the religious claimants based on the federal religious liberty statutes that I mentioned. In terms of the Supreme Court free exercise precedent, I think it's fair to say that both Hobby Lobby and Holt v. Hobbs probably would have been decided differently under the court's existing precedent rather than under RFRA and RLUIPA, those statutes that I mentioned. In Hobby Lobby, the Supreme Court applied RFRA to invalidate the contraceptive mandate of the Affordable Care Act. Hobby Lobby's objection reflects a mainstream Christian view, and in the case of the Greens, an evangelical view that life begins at conception and therefore any destruction of life after conception is sinful. Hobby Lobby objected to 4 of the 20 types of contraceptive methods required to be provided by the mandate, 2 types of morning after pills and 2 types of IUDs, although it had no objection to and was then providing the other 16. Because they failed to provide all 20, it would then require them to pay several million, about $475 million per year in penalties. But the Hobby Lobby case also brought attention to broader objections that had been raised earlier by Catholic hospitals and schools who objected to the entirety of the mandate. Hobby Lobby reignited the argument over whether religious individuals and groups should be granted exemptions from generally applicable laws, particularly in cases of laws justified with respect to other important group interests, such as women's health or access to contraception. The size and commercial nature of Hobby Lobby raised questions about the cost of religious liberty on society. And the explicitly Christian nature of the religious claim meant that it was more familiar, but in the context of the culture wars perhaps, somewhat less sympathetic to some than claims made by non-Christians or members of minority religions. At the core, Hobby Lobby's asserted burden was accepted as religious in light of the views of its owners. The commercial nature of the enterprise, an issue that dominated most of the coverage of the case and attracted the attention of some of the dissenters, did not preclude the application of the Furr statute. Ultimately, the court ruled in favor of Hobby Lobby, as everyone knows, as you probably have read in the papers or saw on TV, under the balancing test mandated by RFRA. Applying the contraceptive mandate to Hobby Lobby was, in the court's words, not the least restrictive means of achieving its compelling interest in guaranteeing access to women's health with respect to those 4 methods of contraception. The government could provide the contraceptives directly under the combination already given to the nonprofits, and so for that reason, the court found that Hobby Lobby employees would ultimately be entitled to access to those drugs without Hobby Lobby being required to provide them. Now, Holt v. Hobbs, the case that I mentioned earlier this year, is a very different case. That one was a unanimous case. Hobby Lobby was 5-4, Holt v. Hobbs was 9-0, which applied that other statute, RLUIPA, to invalidate an Arkansas prison regulation forbidding the wearing of a half-inch beard by religious inmates. So as a Muslim, Holt's religious beliefs require the wearing of a beard. He suggested a half-inch beard as a compromise position for his religious beliefs that really required a full beard, but the Arkansas prison refused. And there was a funny moment in our religious liberty litigation class. The advocate before the Supreme Court was speaking to the class, and so he talked about the most difficult moment for him at oral argument, and he got the question, I think, from Justice Scalia about the half-inch beard, and he said that the claimant, Gregory Holt, suggested it as a compromise position, and the argument that he got back from the bench was, well, how can you compromise what the prophet dictates on one? What authority does he compromise his religious beliefs? And so he struggled with that question, I think, a bit. But that was his position, that the half-inch beard would be a sufficient accommodation and not a burden on his religious practice. So it turned out that the prison already made a medical exception for a quarter-inch beard, but it did not permit any religious exceptions. Unlike Hobby Lobby, Holt's objection reflects a Muslim view, a minority view. His original petition to the Supreme Court and a lot of his early litigation wasn't even supported by lawyers or prepared by a lawyer. He was and is a religious minority in every sense of that term, but his burden amounted to the government preventing him from carrying out a religious command. The government had asserted a compelling interest in safety, but the fact that it had made other exceptions, and notably that a majority, apparently about 43 other prisons, were able to make the accommodation, meant that the government had not satisfied that balancing test. And so the outcome in Holt v. Hobbs decided under RLUIPA, that statute contrasts with an earlier Supreme Court free exercise case in which Muslim inmates lost under a more deferential standard of review that had been used in prison cases. As I mentioned earlier, Holt was represented, among others, by the same litigation firm that represented Hobby Lobby, the Beckett Fund, which stated that it exists to represent the claims of religionists from A to Z, from Anglicans to theists to Zoroastrians. Likewise, a major proponent of prison coverage in RLUIPA turned out to have been an evangelical group, Chuck Colson or Charles Colson's Prison Fellowship. So today, if we think about where religious liberty stands in terms of those religious liberty statutes, these statutes offer a robust vision of free exercise as part of a mosaic of religious liberty and pluralism. And this pluralism is one that can be and has been embraced by people of different faiths and religious views, including Christians, and has been and can be used to protect people of differing faiths and religious views, including Christians. Now, it would be incomplete to fail to note the splintering of some of this form of religious pluralism, certainly in the wake of 9/11 and concerns about religiously inspired terrorism. So for example, some of the advocates for religious liberty that might have been reflected in some of the earlier cases have been on the opposing side of religious liberty in land use disputes involving mosques, for example. But there were a number of religious liberty advocates that nonetheless support religious liberty for everyone. And so I have sort of a postscript here, I think, toward the end. We've got those two cases that I mentioned, the most recent cases, and this idea of pluralism. But I want to add as a postscript just one recent case that's now presently before the Supreme Court on this idea of pluralism and religious liberty for everyone. And that case is Abercrombie & Fitch versus EEOC. And so that's a case involving Title VII. And Title VII is an employment discrimination statute. It protects religion. It requires that employers reasonably accommodate religion, and there are some sort of precise technical issues before the Supreme Court, and I don't so much want to get into those. I really want to bracket the tone of advocacy in the case. And so the precise legal issues in the Title VII case involve a Muslim woman, Sandra Eloff, who sought a job with Abercrombie & Fitch while she was wearing a headscarf. And so the sort of legal issues before the Supreme Court is whether an employer has an obligation to ask about religious accommodation, how that's supposed to work in the context of an interview. But what I wanted to do, as I said, was to note kind of the tone of the advocacy of the case. And one of the things that's striking in the case is that if you take a look at the amicus briefs, and that means friends of the court, so briefs filed by groups, individuals, and advocates urging the court to take a particular position or make a particular decision. If you look at the amicus briefs, they're pretty much lopsided in favor of Ms. Eloff, and certainly people can disagree about Abercrombie & Fitch's policy or ultimately what they should be required to do. People and lawyers certainly can disagree about the technical issues around Title VII and how that interview conversation has to go. But I wanted to note the authorship of one brief, which represents an array of religious and legal groups, and here's the list. So the Christian Legal Society, Seventh-day Adventists, Church of God in Christ, the Orthodox Church, the Baptist Joint Committee, the National Association of Evangelicals, the Sikh Coalition, the Jewish Partnership for Justice, the American Civil Liberties Union, the American Islamic Congress, and Muslim Women Lawyers for Human Rights. By the tone of this advocacy, I think, and the advocates that are represented and the individuals and groups that they represent, I think we can see that there's an apparent consensus, at least by many religious advocates, that her case, Eloff's case, is like the RFRA and like the RLUIPA, supported by a pluralistic view of religious liberty. And so if I haven't taxed your patience enough, I want to end just with a quote from one of the briefs in the case. And if you're looking for, if you're going to go and take a look for this brief, this happens to be, again, the Beckett Fund's brief in the case. But here's some examples of how they describe, or rather an example, a description really, of their work. And so they say that their work is fueled by its belief that the religious impulse is inherent in human beings and that religious expression is natural and inevitable in all aspects of human life, thus preserving a broad right for all sincere believers to freely exercise their religion in private and in public is essential to upholding both individual human dignity and the moral foundations that support a free society. Thank you for allowing me to open this conversation on religion and law and pluralism and religious liberty, and I look forward to hearing your questions and also what Dr. Moore has to say.
Thank you, Professor Roy. Please welcome with me then, Professor Moore.
Thank you very much, Professor Boss, and I also would like to thank the Department of Philosophy and Religion and the Furr family and the Furr Foundation for inviting me here today. It's a great pleasure to travel from Santa Barbara to visit Mississippi and to join this august gathering to talk about these important issues about religious pluralism and religious liberty. I was asked here today to talk about Sharia in the United States, and I'm very happy to do so. I want to share some of my research, my recent research with you. But first, I think I should ask the question, what is Sharia? And attempt an answer, which will be incomplete. Sharia is a word that many Americans have heard of by now. So what does it mean? How is that word usually translated in, when you're reading newspaper articles? Usually in the press, the word Sharia is a stand-in for Islamic law, and that is actually an accurate translation. But Sharia means much more than Islamic law, and that's what I want to share with you today. And before I talk about Sharia, though, I want to begin by providing a preface to my argument, and that is that religious self-determination is deeply embedded in the constitutional and statutory framework of American law that Dr. Roy just reviewed for you, even if that idea is not fully accepted by the American public. And I like to say that Muslims have a much easier time finding a favorable reception in the courts than they do in the public mind. So what are the implications of this idea about religious self-determination? Well, first I want to talk about, what we all generally have a sense of what self-determination means. We talk about nations having self-determination in the 20th century. It was about nations establishing the sovereign right to determine their own independent path. And if we talk about individuals, then self-determination in general is also about the individual establishing a sovereign power to determine the meaning and purpose of one's life. So like self-determination in general, I posit that religious self-determination is about the ability to determine one's own destiny. It's the ability of groups and individuals to enjoy the values of life, prosperity, freedom, and human dignity. And when we talk about religious self-determination, it is especially effective when involving the younger generation, the empowerment of women, and the economically disenfranchised. Talk of the role of religion in the process of determining one's self and one's future has largely been framed, of course, in negative terms. When we think about ISIS in Syria and Iraq, when we think about Al-Qaeda and the rest of the Muslim world, when we think about their religious self-determination, of course, that doesn't look like anything we would like to have. If that's religious self-determination, then I don't want it. But yet, if we think about our own country, we're still debating whether America is a Christian nation, a Protestant nation, or a nation that is secular. And the talk about religion has had an important role to play in defining our own nation from the beginning, from the framers of the Constitution. So it has an important role to play in identity formation of our nation and of our people, and religion gets to the core of what people are and strive to be. Religion is a stand-in for the striving for ultimate realization, and it also means, for some, the union with the divine will. Religion is never abstract. It is very specific, and it affects our everyday lives, whether we consider ourselves to be a religious person or not, because religion animates individuals, but it also animates communities and nations. So it has an impact on shaping our nation, as our nation also has an impact on shaping religion. So for that reason, religion becomes an even more powerful factor when we're talking about self-determination. Now, another reason why I use religion as a modifier for self-determination, which I think may be even more significant, is that as religious people may understand the movement of their lives as not self-determined, but as co-determined with God's will. And so religious commitments may be recommending a certain course of action. Religious commitments may recommend what is worth striving for. And religious commitments may also provide a sense of eternal or cosmic time as opposed to temporal time, and also could sustain the endurance of the people in their efforts. When speaking of religion's influence on self-determination, then we may say that rather than being an opiate, religion functions more like an amphetamine. And so in Western democracies in recent years, we've witnessed some dramatic and often highly charged debates about the role of religion in its public presence in our pluralistic societies. And just to name a few, there are 3 debates about Islamic law and the limits of pluralism in a liberal democracy that I want to mention. First, in Ontario, Canada, there was a debate in 2004 and 5 about whether in Ontario religious groups could continue to use private arbitration as a means to resolve intra-communal disputes. In Canada, in Ontario, there was an Islamic arbitration decision and a group that became subject of this debate. And then similarly in the United Kingdom as well, the Archbishop of Canterbury, who's the head of the Anglican Communion, Rowan Williams, suggested that British commitments to pluralism might require the English legal system to recognize certain aspects of Islamic law. He said this question is unavoidable. And perhaps the most relevant debates is the third category I wanted to mention. The debates about Sharia, or Islamic law, in the United States were instigated by the wave of Ban the Sharia initiatives that spread through several states between 2010 and 2012. Now, there is no empirical evidence to show that Islamic law is supplanting American civil law. We have not been in any danger of the Constitution being supplanted by the Quran. In other words, there are no groups that are advocating for Islamic law or Sharia to be enforced through state courts. However, it still remains a fact that Islamic issues have been germane in the context of American law, as Dr. Roy referred to the wearing of the Muslim headscarf in the workplace and the wearing of facial hair in prisons are just 2 examples of that. So we want to think about that. It was in the wake of these events that I just mentioned that I decided to conduct a study of what Sharia means for many Muslims in California. And so I've done a 2-year in-depth study of the experience of and attitudes about Sharia as a system of norms and laws in the West. This is the project called Sharia Revoiced that Dr. Boss had mentioned in the introduction. In doing this research, I have, in the process, done extensive interviews with over 100 Muslim Americans residing in California. Motivated by the events that were just mentioned, I thought if states are proposing to ban the Sharia from state courts, then the logical question is, what is it that we're banning? What is Sharia? Efforts to curb the influence of Sharia beg the question, what is it that we want to prohibit? So because these debates collapse a lot of nuances and prevent a lot of potential creativity in solving some of the complex tensions between law, government, and constitutionalism in our world today, it's important to try to figure out what it is that Muslims may be demanding. So I've done interviews with 100 average Muslims, and by average I mean they're lay people, not necessarily trained in Islamic theology or law. So I've interviewed 100, or approaching 100. I'm in the 90s now. I'm still conducting this research. The study goes until the end of the summer. But my target is to aim to interview 100 lay people and also 30 specialists. And these would be imams and others who are working in higher education as scholars of Islamic law across the state of California. Asking what is Sharia, I asked them what is Sharia in their estimation and whether Sharia is relevant in their daily lives. What I have found so far has been very interesting. I have many interviews yet to read and analyze, but I'll come back to this in a few minutes. First, I want to define what Sharia is considered to be, conventionally speaking. I think in order to understand this, we need to look at a textbook definition as our starting point. So I want to say a little something about the basic concepts, how I understand some basic concepts and categories of authority, and whether legal authority is where legal authority is located for Muslims. So if you take a classical definition of Sharia, to call Sharia Islamic law is technically an accurate translation, but it is also misleading because it gives you only one part of the whole picture. Sharia is really God's law, or divine law. Sharia literally means the path, or the way to the water spring. So it is an ideal, an aspiration that people have. It's an ideal about how people should be in the world, and it defines the human's relationship to the divine, as well as the human relationships, how they relate to each other. So it's the idea of the way God is commanding people to act and to live. Now, Muslims have information about what Sharia is from two sources. The Quran, which Muslims consider to be the divine word of God revealed to the Prophet Muhammad, and the Sunnah, which are the ways or the lived example of the Prophet Muhammad, who Muslims say is the last in the line of all Abrahamic prophets. So, between the Quran and the Sunnah, that's the information we have about God's law, or Sharia. And for many Muslims, this is considered to be immutable. You cannot change. But of course, these cannot give you the answer to every possible life and legal question that you would encounter. So the jurists, or the legal scholars in Muslim society, developed a science of interpreting those texts in order to develop specific legal conclusions. Those conclusions, which are accumulated over the course of 3 centuries, constitute Islamic jurisprudence. And the word for that is fiqh, which derives from the word for understanding. So in its very core, fiqh, or jurisprudence, is about the human intellectual project of attempting to understand the meaning of Sharia, or God's will. And those conclusions, as I mentioned, accumulated over 3 centuries, are a body of jurisprudence. They're a body of doctrine. In positivist law, they're written down as rulings of courts and religious legal scholars, which is what we usually think of when we think about Islamic law in the sense of the rules governing Muslims' behavior. So you have Sharia, but you also have fiqh. And in America today, there's an increasing trend to distinguishing between these, that Sharia is different from fiqh, and then priorities range from there between these two. So to do their work, the jurists in medieval period invented several jurisprudential tools, including linguistic canons of construction, analogical reasoning, which is very similar to the case precedent reasoning that we see today in common law and in our system. Maslaha, which is the idea of public welfare, which is to guide, take precedence in decision making, and consensus, which is a consensus of the scholars on the meaning of things, and so on. These tools make up the field of Islamic jurisprudence, or are considered the roots of Islamic law. The interpretive work is called ijtihad, which, as you can hear, comes from the same root as jihad, which is an effort or a struggle, not a war. And ijtihad is the struggle to ascertain meaning. It is the struggle through legal reasoning, or in other words, the serious effort made in answering legal questions by analyzing and interpreting the divine sources. So different schools of thought arose from the Middle Ages forward based on differing interpretations. There's pluralism within Islamic jurisprudence. In other words, coming down to today, we still have 4 major schools of Sunni thought about the law and 1 major Shiite school about Islamic law, which are filtered down through different regions, but also the application of these jurisprudential tools that I just mentioned. So we need to keep in mind, even when we talk about the application of Islamic law in the West, if we're thinking about fiqh, one first has to answer the question, whose law? from which school. Given this, the tension between Sharia and fiqh, with Sharia being immutable and fiqh not so much, because fiqh is, after all, the product of intellectual reasoning, is subject to human fallibility because it is a human project. You've got that tension between Sharia and fiqh, and which one is more authentic and has more authority. Also, with fiqh, you don't get one body of jurisprudential doctrine, you get quite a few. So you can get different understandings of God's law. Which one of these demands a faithful Muslim's loyalty? We can't think of this as a monolithic code that's going to provide the right answer that will be imposed by a theocratic authority of some sort. Instead, Muslims might view God's law at the center and recognize human fallibility in interpreting God's law, and realize that in Islamic history there have developed distinct methodologies of human interpretation that have resulted in distinct schools of law. So if you look up answers to some basic Islamic questions, you're going to find some reference to these different schools on a lot of different doctrinal matters. And they actually matter on the ground in some very specific ways. For example, in prayer, a follower of the Maliki school of thought will hold his or her hands and arms differently during prayer than in any other school of Sunni thought, for instance, holding whether this way or this. And the existence of multiple schools side by side illustrates the jurisprudential reality that when a jurist holds an opinion on a matter, it really matters, because his opinion, rather than yours, might actually ultimately be the correct one. There's something and whether who has the correct opinion is something we won't know until the Day of Judgment. There's a saying of the Prophet Muhammad that I think is an excellent illustration of that point. The saying is that the one who has done ijtihad, the effort of legal interpretation, and arrives at the correct answer will receive 2 heavenly rewards on Judgment Day. And the one who does ijtihad and arrives at the wrong answer will receive only 1 heavenly reward. So from that you can notice that no one gets punished for the wrong answer. There's something valuable in the jihad work itself that makes it commendable. So there is always an encouragement to do ijtihad regardless of the outcome. And secondly, this is very important for the context of pluralism, we on this earth won't know who has the correct answer and who is wrong. At least we won't know that in our lifetime. So if 2 jurists come up with different answers to the same question, we must operate always with the possibility that one jurist is getting 1 reward and the other will be getting 2. So this creates the necessary appreciation for legal pluralism and toleration of the other's perspective, because under these conditions, the most a jurist's conclusion can ever claim is having a probability of being true and not absolute truth. So in theory, if not always in practice, Muslims respect opposing schools of Islamic thought about theological questions because there's an inherent recognition that some answers are more commendable than others in the eyes of God, and we won't know that until the Day of Judgment. So I brought up that explanation in order to illustrate that there are multiple interpretations of Islamic law, and there remains open the question of authority. Who has the authority to provide answers and ultimately to say what is God's will? So my research topic in Sharia Revoiced is about how, if at all, are Muslims discussing Sharia in their everyday lives? How are religious values being produced or reproduced, debated, and challenged in the course of these conversations? Is Sharia understood simply as Islamic jurisprudence, the intellectual project of traditional authorities overseas, or is it something more? Finally, how do Muslim Americans navigate religious law when living in an ostensibly secular state? And looking at the lived experience of Muslims in California to understand how Californian Muslims are trying to orient their lives around their own understandings of the teachings of their religion, whether they accept or reject or modify those teachings, and how these teachings are understood locally. The methodology I did, semi-structured interviews with a wide range of individuals in urban settings across California, wherever Muslims were engaged in challenging and producing knowledge of Sharia. That might be in Quranic study groups, in coffee hours, in women's groups, youth groups, in an Islamic college. There's now an accredited Islamic college called Zaytuna in the San Francisco Bay Area, and a graduate school of Islamic theology called Bayan, which is in Claremont. In mosque-based discussion groups, in community centers, and in the home. I tried to get many unmosqued Muslims as well as those who attend mosques regularly, because only 20% is estimated of Muslims in America attend mosque regularly. So it's important to get representation of those who are unmosqued. And I talked to feminists, youth activists, teachers, students, professors, artists, clerics, housewives, professionals, business people, and the elderly in order to get a diverse range of experience. I asked questions about personal matters, about major life events when people ordinarily face moments of stress, what I call my 3 C's, moments of change, challenge, and choice. My method is to follow the grounded theory approach of building theory upon the analysis of data collected rather than the other way around, which is to go out and collect data in order to prove or disprove a hypothesis. So the approach is to gather the data and examine the meaning of Sharia as it emerges in the data across different life experiences, using hermeneutic phenomenology to focus on the lived experience of the participant being interviewed. Participants have ranged in age from 21 to their late 60s. To date, I only have 38% of my participants as women, and I'm working on improving that score by identifying more women who are willing to be interviewed. I ask participants to relate to me a time in their lives when they've had a major life event, such as going away to college, deciding to get married, choosing to start a family, and losing a loved one. Then we engage in a conversation about whether Sharia was relevant, and if so, how, and so on. And I ask people to walk me through their decision-making process and whether Islam or Sharia played any part. Most of the interviews indicated that Sharia is indeed personal and what some call extra-legal. In other words, outside of the parameters of jurisprudence. It is not an area in which government or the court system is competent to act. Neither are religious scholars necessarily the place where Muslims locate authority to interpret. Rather, Sharia is defined as a highly personal relationship between a person and her God or inner conscience. One respondent said, there is nothing like cosmic Sharia. Instead, it's very local, personal, and contextual. So one respondent that I wanted to talk about, one situation was where I interviewed both the husband and wife, each of them 2 times, about their decision to, well, they talked about various events, but the one I want to talk about is their decision to adopt 2 children out of the California foster care system. And this couple, the husband is a physician and medical ethicist, and it calls himself an activist in Southern California. And his wife is a lawyer. She had grown up in California and went to UCLA and then attended law school at Wayne State University. And she was a civil rights lawyer in California until she decided to form a family and became a stay-at-home mom. The husband was talking about this issue of adoption, and here's what he said. He says, the biggest issue I dealt with in adopting 2 kids is adopting 2 kids. When I asked about life events, he says, the biggest issue I dealt with was adopting 2 kids. Some colleagues of mine said to me, look, you have to adopt under the age of 2, and your wife has to breastfeed. That's Islamic religion. But in this day and age, you can't talk about women's bodies like that. We have to reconcile. We adopted 2 kids over the age of 2, regardless. Some people telling you, you shouldn't do this, but it shouldn't take away your ability to love and care for them. No one sees the extra-legal. There's a Sharia legal responsibility. That's in the books for ages. What about your ethical responsibility? Do I see that happening? Like her wearing a hijab when she's 20 in front of me? I don't see that happening, so I'm violating Sharia. That's a big issue we talked about, my wife and me. Now here, the respondent vacillates between Sharia being fiqh, understood as jurisprudence, in which case he would be violating Sharia, technically, by having what he says is she standing in front of me wearing a hijab when she's 20, meaning that the daughter that he adopted, when she reaches a certain age beyond puberty, would she have to cover in order to be modest in front of her adoptive father, because there is no biological link. This is some of the argument in Islamic theology against adoption. And so he's referring to that, and he's vacillating between this fiqh, in which case he would be violating Sharia, and what he calls the extra-legal, the ethical dimension of Sharia for him. And clearly it's a problem, it's a dilemma, but he suggests, or at least the subtext of this passage, is that he would contest the validity of the rule that would say his daughter must be covered in front of him. His wife, who is the adoptive mother, presents an interesting case. She's trained as an attorney, as I mentioned, graduating from UCLA and Wayne State, and works as a civil rights attorney. She's raising 2 children that she and her husband adopted out of foster care. In asking her about the thought process in reaching that decision, she indicates that she spoke to imams, who are prayer leaders in the mosques, and family members, and encountered several questions. Basically, her decision was challenged by those who said that her children would never be mahram. Mahram means those are people that are not eligible to marry you. A mahram would be somebody that you are in close relationship with and so therefore could not marry. So your biological children are mahram. Now, this respondent rejects those arguments because she rejects the notion that adopted children are any different from biological children in that respect. She says, if I have to wear my hijab in front of my son when he's 12, so be it. Again, when the child reaches age of maturity, then there is an obligation to practice modesty, but not between biological relatives. Others said she should give this child breast milk from a biological relative of hers, and that would then overcome this problem. Then the child becomes mahram, having been nursed by breast milk. But she says, are you kidding? What do you want me to do, spike his morning cereal? And she laughs. So she denigrates this very concept. She said she still gets into heated conversations with her family, even after the fact that she's adopted children over the age of 2. So I asked her about that. She says the conversations continue, but not with respect to her kids. She says, since I have another family member who's adopting overseas a baby, inshallah, so she wants a baby so she can breastfeed him, so she can be his mahram. And I was just sitting there, and I was just like, finally I said, you know, my husband and I have a different perspective on all of this. And I was like, the way I respond now is, still I don't care if they're mahrams under the legal definition, because to me, that legal definition is antiquated. It doesn't, and I've looked into this, done some online research too. Where this situation, where kids cannot be with a biological family, it's been tried and they can't, and the only option is to go into group homes and never have a family their whole life. Like, how is that an Islamic option? And like for me, you know, and then I interrupt her to ask, I said, you had to use your legal skills to do your research on this Islamic legal issue? She responds, yeah, I don't have my HIFs. The HIFs is a certificate, a degree that she has studied with Islamic legal scholars. She said, I didn't go abroad and study. My husband always makes fun of me because he always says, oh, Dr. Sherman Jackson said this. And Sherman Jackson is an African-American Muslim professor of Islam at USC. So she refers to Jackson apparently in her arguments. So he's an authority in her mind. So she goes on to say, I'm like, addressing her husband, I said the exact same thing a year ago, and just because Dr. Jackson said it now, and laughs. And he's like, well, he has this ijazah and all this stuff. And I'm like, I have my brain. And you know, I have a direct connection to God because, you know, he created me and put this brain in my head. So, but like with these kids, what does a mahram mean? You can't marry them. I can't marry them. These are my kids. I think even under state law, you can't marry adopted kids. So by that technical definition, they're my mahram. So this exchange is important because it exemplifies how Sharia is defined by her as a rational process of self-reflection and relies very little on and even contests more conventional understandings of jurisprudence. She also relies on state law to back up her position that her son is too close of a relationship with her to be marriageable. So by a legally technical definition, in other words, by the laws of the state of California, the child and both children are rendered mahram. That example reveals the general finding so far of my study, which is very preliminary because, as I said, I'm still doing interviews. But the example reveals a general finding of the study, which is that the informal processes of applying Sharia to everyday living, decisions about forming a family, for instance, are occurring even though these are generally considered extra-legal debates and just as often contest the rulings of religious jurists. So such informal processes are occurring because they're desired by those involved in important family-oriented decisions. None of the people I've interviewed advocate establishing a formal legal apparatus or legal status for Sharia, preferring instead to retain the civil law system as well as the freedom to make informal Sharia-based decisions when desired. Also, there's very little agreement among American Muslims about what Sharia means in terms of its application, and there is much debate over kitchen tables about the core principles. While much information is being promulgated by the mass media about creeping Sharia, Muslims' views about the subject remain diverse. I'd like to end it there and return to the chair and open this for a conversation with you. Thank you very much.
Thank you so much, Professor Moore. We'll take about 30 seconds for those of you who need to exit quietly, and then we'll begin the question and answer session. Those of you who ask a question, I would ask that you would stand and speak as loudly as possible, and then address which of our panelists will be answering it, potentially both. Do we have a first question? Yes, Bruce.
Thank both of you for very excellent lectures. My question is relative to if you pose a similar interview questionnaire to Christians about the Bible and the relationship that you so well define across Sharia versus the jurisprudence definition, action, interpretation, what would you presuppose your findings concerning a Christian perspective?
Well, that's a good question. I think, I don't know if this is on, but do I even need it? I don't know.
Might not need it.
I probably won't need it. All right. It's a good question because it's comparative of religion. And I think that when you think about Catholic canon law, how many practicing Catholics in America are aware of what canon law is or says? And when you think also maybe in the case of Jewish halakha, there may be a little bit more awareness on the part of your average Jewish person about the existence of Jewish law and how it might apply in their everyday lives. But for Muslims, this has really been brought to the forefront in their consciousness specifically because of the political discourse and all the polemics about the place of Sharia in one's faith. And a lot of the interview subjects I talk to say to me they don't know what Sharia is, and they say they never heard the word Sharia. It wasn't part of their common vocabulary until 9/11, and then obviously later with the mosque cases that Dr. Roy mentioned, that it wasn't something they talk about. That's not the word that would have been used. And yet, components of Sharia is still embedded in their lives, because if you eat halal, which is like eating kosher, that is in fact being compliant with Sharia law. So words like halal or haram, which is the forbidden, would have been used, but not sort of the big picture meta word of Sharia. So I think that there are ways of comparing it, but I think that in this day and age, because of the particular circumstances we're living in, that there's more of a connection between the Quran and daily living, or Sharia and daily living, than there is for many Christians between the Bible and some of these legal constraints.
A second question. Yes, sir.
Dr. Moore, you said a lot of people, when you talk to follow Sharia as more of a guideline, that they navigate their opinions based on not so much a concrete law. What was your experience with people who followed more fundamentalist, I guess more strict opinion of it?
Right, okay. Well, I don't know, I call them fundamentalists, but more, let's see, compliant with jurisprudence, compliant with Islamic law as it was interpreted by medieval jurists. There are a lot of the imams that I speak with who want to talk about that as, you know, and not recognize that it's like looking at the Constitution. I think we were talking about this earlier today. You look at the Constitution and you never think about how people are not always, you know, compliant with the law. They're not living up to the letter of the law. It's an aspiration that we hold, but not something that people live with every day. And the same is true. Imams have a hard time. They're a little bit more doctrinaire about, you know, this is what the law says, so this is what we do, without talking about how there's a great deal of variation among their congregation. An example of this would be an imam talking about how he was raised in Southern California of a particular school of legal thought, and then he had kind of a conversion experience and became more devout and decided he was going to become an imam. Went back to Cairo to study at Al-Azhar, switched schools of Islamic legal thought to join the predominant one at Al-Azhar, and came back as an imam of his mosque, having changed his prayer practices in accordance with this new law, the school of law is now practicing. But he doesn't recognize, you know, I asked him about, well, how about your parishioners? How about the people in the congregation? Well, they're practicing whatever they believe, and there's a great deal of pluralism in the way they perform their prayers. But it isn't something at the official level that he's talking about. You have to talk to the layperson to find out that they're praying in different ways, and sometimes that gets accepted, and sometimes people are very critical of that. You know, you're praying like a Shia. You shouldn't be doing that here. So, yeah, I mean, I think people who are charged with being the specialists, being the professionals in this, want to talk about it more at a theoretical level rather than the practical level.
Another question. Yes, sir.
Dr. Roy, is there a next big case that the Supreme Court will need to address regarding church-state issues that you see coming up?
Well, I certainly mentioned one that's not exactly a church-state case. That's more of an employment discrimination case. There was a recent case, in fact, my students just ended up talking about this very recently. There was a recent case in which the Supreme Court denied review, and that was a church-state case involving a number of churches that wanted access to school facilities for their church services in New York, and that had spanned maybe 20 or so years. There are always kind of religious symbols cases on the horizon, and so there's one in California that may get resolved without going back to the Supreme Court, although there is some interest on the part of some of the conservative justices to take a case like that. And so that may be a case that we see, but in terms of one particular case that I have in mind that's coming up next, I don't.
Other questions? Yes, sir.
This is for Professor Roy. You had mentioned something about state religious freedom restoration acts and state constitutional equivalents. Do you have thoughts on the recent controversies about those? We had Arizona and Mississippi controversies a year or two ago, recent Indiana and Arkansas controversies. Could you say a little bit about those issues and what you see happening in that area?
I'm sorry.
Well, Professor Roy, but either.
No, you go ahead.
So, yes, it's kind of hard to ignore those controversies that have been erupting. As you mentioned, Mississippi passed one last year. There was certainly some controversy around that, and then Indiana and Arkansas. So I guess the first thing we can recognize is that those state RFRAs are essentially children of the federal RFRA. And so there's kind of been this long process of states developing RFRAs, and we know that the ones that have recently been enacted have been enacted in the context of a particular type of dispute. And so, and that's involving usually religious service providers associated with gay and lesbian weddings or civil unions and things like that. And so the famous case, the Elaine photography case out of New Mexico, involved a photographer who had a religious objection to participating in that type of commitment ceremony. And so, certainly, I think RFRAs will continue, at least in the short term, to be controversial for that reason, because there are kind of these opposing views. One of the interesting developments, I think, in the state RFRA movement was that fracturing that I talked about in terms of the coalition to support on both kind of the sort of the ACLU and Justice Brennan and very liberal and more religiously conservative folks on the other hand to support the RFRAs. That fracture is not likely to be repaired, and so with that being the case, I think they'll continue to be controversial, and of course states have handled that in a number of ways. And so the recent ones that we talked through that you mentioned, that I repeated, the Arkansas and Indiana, the way that those have been handled have been to make some modifications, because some of the more controversial, I guess, aspects of those, or things that have concerned critics the most, have been whether they apply in a commercial setting, and then whether there are carve-outs for anti-discrimination laws. And so I think Indiana ended up making a carve-out for anti-discrimination laws for service providers, with an exception for, I think, churches and pastors and very strictly religious people in the non-commercial setting. And so that may be the way that gets navigated, but kind of on the, so if your question was also just how do I see that fitting in with what I talked about, I do see it as a religious liberty issue, and I think that to the extent that there's any political will on both sides to come together and talk about the terms on which the groups might agree to sort of live and let live, I think that would be desirable.
We have more questions. We might have time for two more. Yes, sir.
Dr. Moore, you talked about Muslim men and women who use Sharia law as a guideline to live their life, which sounds like a nice thing. But are there any negative or harmful connotations of Sharia law? Because there is a significant amount of fear and concern in the minds of Western civilization if the law of Sharia is to be implemented in major Western countries. So why is that fear? Is it because of any negative connotations or misinterpretations of Sharia law?
Right, I mean, as I mentioned, there is, I think, a lot of misunderstanding or lack of knowledge about what this is going to mean, because we're using these very generic terms like Sharia. And so the details have to be filled in. But I think that in the American case so far, there hasn't been, that fear of Sharia, creeping Sharia is not well founded, because there hasn't been a demand on the courts to uphold the terms of Sharia agreements. I mean, we talk about the role of religious arbitration tribunals. There have been a few isolated cases that have been local cases of arbitration according to Islamic law within family law. And whenever the arbitration award comes up to the state court, because it has to be affirmed by the state court to be implemented, the courts have denied, they want to uphold the arbitration awards of things that seem to be unduly unfair. So there's a core principle of justice about equality that can't be replaced by Islamic law. So an example would be arbitration of a family marriage dissolution. And according to the law in all the states, that only state courts can, pronounce a divorce, can have jurisdiction over the dissolution of a marriage. But it's within the terms then what can happen to the division of property, or what can happen in terms of child visitation. Those kinds of things need to be arbitrated according to Islamic principles. Now, when there has been an uneven division of property that skews in favor of the man, then those are not upheld by the states, because they say we have community property law or whatever it applies in the state, which is based on an equality principle. So they don't uphold those kinds of decisions. So already we see in practice that there are serious obstacles to the implementation of Sharia in the court system here. And as I was mentioning before we started here to Dr. Roy, it's really, I think, a matter of lack of experience that we have many religious arbitration tribunals that are about Catholic thought, and there are Jewish religious arbitration tribunals that have carved out an area of success in applying their laws. But Muslims are very new to the block, and this has to do with the question of pluralism. Immigration laws changed in 1965, so now we have many more Muslims in America as a result of immigration from Asia and the Middle East. But it's really changed, I think, the landscape, as Dr. Roy suggested with the amicus brief that she read. I mean, just listen to the list of faiths that were represented: Buddhists, Hindus, Sikhs, Muslims, and so forth. So religious pluralism is looking much different today. And I think, it has yet to be seen how Islamic law will be implemented, if at all, in this American system.
One final question?
Professor Roy, I'm trying to get my head around the Hobby Lobby case and others like that. Hobby Lobby is a corporation which, by design, is a legal fiction. It's an abstract entity that is separate from its officers, and that's the purpose for corporations, so we can sue them, but the officers would not get sued. A corporation doesn't have any beliefs, so how can a corporation have religious sensibilities or religious rights? How does, in these rulings, how does the law get around that problem?
So that's a good question. There are a couple of ways. And so the view that you described was really the view of one of the circuit courts that went up before the Supreme Court. And so one ruled along the lines of the kind of reasoning you described, saying, in fact, that the corporation was a separate entity, that it didn't have religious beliefs. And the 10th Circuit ruled that the corporation in that case, in fact, did constitute a person and therefore could exercise religion. So the couple of ways in which the court surmounted that hurdle was by one, looking at the Dictionary Act that would apply to a federal statute like RFRA that defined a person and included a corporation as a person. And then I think more to really your question, talked about the owners as organizing this closely held corporation for the purpose of kind of facilitating their own whatever their own goals or purposes were. And so the majority in Hobby Lobby reasoned that, well, corporations are formed by people, for people, and so we can look at those people to determine how they want to carry out and run the corporation. But it was made, I think, a little bit easier. So to the extent that you can accept that reasoning, or to the extent that a person can accept that reasoning, I think it was made a little bit easier factually in case, because you did have just a small number of owners in this closely held organization that happened to share the same views. But that was how the court explained it.
Okay, thank you very much. Thank you for your attendance. Have a nice evening.